Welcome, everyone. We're just going to give one more minute for everyone to join, and then we'll start. Thanks very much. Welcome everyone to our webinar. On behalf of Redress, I'd like to warmly welcome you all. My name is Chris Esdale. I'm a legal advisor at Redress, and I'll be chairing today's webinar. This event, as well as marking yesterday's International Day Against Homophobia, Biphobia and Transphobia, marks the launch of an important report, Unequal Justice, Accountability for Torture Against LGBTIQ+ persons in Africa. This report was prepared in the context of a larger project that we're currently undertaking at Redress, aiming to increase accountability in Africa for violence perpetrated against LGBTIQ+ persons, which will often amount to torture as defined in the UN Convention Against Torture. As part of this project, we're lucky to be working with 4 excellent partner organisations: the National Gay and Lesbian Human Rights Commission in Kenya, and the Centre for the Development of People in Malawi, both of which you will hear from today, as well as Sexual Minorities Uganda and Access Chapter 2 in South Africa. Our work in partnership with these 4 organisations has greatly informed our approach to the report that we're launching today. We'd also like to thank the law firm Allen & Overy, who were involved in the research and the drafting of this report and continue to support us in the project. Our thanks also to Victor Madrigal, who's the UN independent expert on sexual orientation and gender identity, who has kindly contributed the foreword for the report. Before we introduce the report, a few housekeeping rules. Simultaneous interpretation is provided into French throughout the webinar. At the bottom of your screens, you should be able to turn this feature on. Participants in the webinar won't be able to use the mic function, but we encourage you to make use of the Q&A function. So please do write and send your questions and comments there. That could be done anonymously if you prefer. We'll collect the questions as we receive them and use them during the Q&A later. So I'll now pass the screen to my colleague, Renata Pollicci, who will give a brief introduction to the report and its important findings.
Thank you, Chris. Welcome, everyone, and thank you for joining us today. My name is Renata Pollicci, and I'm a legal officer at Redress. Thank you also to our wonderful panelists for being here to add their expertise to today's discussion. I first want to note that throughout the report and in this webinar, we use the acronym LGBTIQ+, which stands for lesbian, gay, bisexual, transgender, intersex, queer, and other gender and sexual identities. Although we use this acronym for clarity, we also know that it, as well as the terms it represents, may be limiting in some instances, and that individuals may identify with multiple or none of these terms. The report we are launching today is the result of extensive collaboration with local partners and experts, as well as research into the challenges that prevent accountability for torture against LGBTIQ+ persons in various states in Africa. It builds on successes within the region, as well as in other regions, including the landmark case of Azudo Rosmarin and Peru in the Inter-American human rights system. The report aims to provide a basis for strengthening efforts in the African region to prevent and investigate discriminatory torture, hold perpetrators accountable, and provide adequate redress to victims. The overarching goals of the report are, firstly, to emphasize the possibility that violence against LGBTIQ+ persons may and often does amount to torture. And secondly, to focus attention on the state's obligations to prevent, investigate, prosecute, and redress such acts in line with international and regional human rights standards. The report examines different themes, drawing on research which was undertaken on 11 states, namely Algeria, Angola, Botswana, the Democratic Republic of Congo, Ghana, Kenya, Malawi, Morocco, Mozambique, Uganda, and South Africa. At the same time, the report reaches broader conclusions and makes recommendations that we hope can be used for advocacy by organizations and practitioners throughout the entire region to strengthen legal protection and to increase accountability for violence against the LGBTIQ community. The report begins with an overview of the legal frameworks against torture in these different states, including the extent to which torture has been criminalized, if at all, and the mechanism in place to prevent and investigate instances of torture, including cases of violence against LGBTIQ people. The report then examines existing laws that protect or discriminate against LGBTIQ+ persons and contrasts the signs of hope shown by recent decriminalization efforts in some states with continued or renewed efforts to criminalize same-sex conduct in other states. The report then takes note of various types of violence observed throughout the region, including violence by state actors in the form of arbitrary arrest, extortion, and harassment, as well as a widespread unwillingness to prevent, investigate, and prosecute violent acts by private actors, which include conversion therapy and so-called corrective rapes, and discrimination and violence against LGBTIQ refugees and asylum seekers. The report then highlights key challenges faced in documenting, investigating, and addressing LGBTIQ violence, and we can group these challenges as follows. One is structural discrimination within institutions in charge of preventing and investigating such violence. Second, the invisibility of the LGBTIQ community and the lack of training of their rights among relevant stakeholders, including policymakers, police officers, prison and border guards, prosecutors, and the judiciary. Third, we look at the limitations on the operation of LGBTIQ organizations. And fourth, we examine the victims' fears of reprisals when reporting violence, leading to a reluctance to report it at all. Finally, the report makes specific recommendations on strengthening the legal protection, improving training on these issues for state authorities and other relevant stakeholders, and also suggests the development and implementation of guidelines on the effective investigation of violence against LGBTIQ people. Our hope is that these recommendations will be considered by states and their institutions, civil society organizations, and the broader community, as well as the African Commission on Human and People's Rights. I look forward to hearing from our distinguished panelists about their own experience working to protect the LGBTIQ community in different states, and I hope you all enjoyed the discussion today. I now pass the screen back to you, Chris. Thank you very much.
Thank you, Kanata. So to lead our discussion of these issues today, we're going to hear from three fantastic panelists, all of whom work to better understand the challenges touched on in the report and how to address these. We're going to hear from Rodney Chalera, who's the program manager at the Center for the Development of People in Malawi. Also from Imani Kimiri, who's the head of legal affairs at the National Gay and Lesbian Human Rights Commission in Kenya. And Ayo Sogunro from the Sexual Orientation, Gender Identity and Expression and Sex Characteristics Unit at the Center for Human Rights of the University of Pretoria. So the way this will work is I'll ask a couple of questions to each of the panelists and they'll have 4 minutes to answer each question. So therefore, our first panelist today is Rodney Chalera. Welcome, Rodney. Rodney is a human rights activist who aspires to build an enabling environment and safeguard the well-being of LGBTIQ+ persons and other vulnerable groups in Malawi. He's the program manager at the Center for the Development of People, a human rights organization in Malawi that advocates for LGBTIQ+ rights. Rodney has worked on a number of projects in Malawi, including advocacy, research, and health programs, with the objective of fostering a culture that values human diversity and supports social justice and wellness for all. So Rodney, as outlined in our report, several factors enable and contribute to violence against the LGBTIQ+ community in Africa, including criminalization of same-sex acts between consenting adults, statements by political figures, discriminatory remarks published by the media, and so on. Like several other states in the region, Malawi criminalizes same-sex conduct. Could you explain, firstly, how criminalization contributes to violence against LGBTIQ+ persons in Malawi? And secondly, how it can also affect investigations into such crimes that are reported to state authorities?
Right, good afternoon, everyone. As the question that I've been asked, one thing that we have to know is that criminalization of same-sex relationships in Malawi affects LGBTI because everyone's attitudes and minds are influenced by the fact that our penal code criminalizes same-sex relationships in Malawi. So to talk about the extent to which this has affected the LGBTI people, the first thing that we have to know is that people get arrested in Malawi for offenses that are termed to be sexual in nature, more especially if they are to do with the same-sex partners. So apart from the arbitrary arrest or detention, which normally happens just by perceiving somebody's sexual orientation or gender identity, there are also verbal abuses that also are suffered by LGBTI people in the country, which may be by the general public or by even the state actors. So getting down to the state actors, you'll find out that LGBTI people are usually beaten up, especially if they are presented to the police. Apart from that, if they have any other case, for example, if they are perceived to have contravened the laws of Malawi, they may be forced to go for forced annual examination, which is against human rights. But this is actually paid by the state actors. So you find out that the health service providers may actually do that to a human being. They may also be subjected to physical beatings by the police. The issues of blackmail that also happen within the country, and also the general harassment. For example, issues of undressing somebody in order for the public to confirm whether they are male or female, especially if their gender identity and expression does not go hand in hand with the sex that they were assigned at birth. So you'll find out that there are quite a lot of challenges that LGBTI people experience in Malawi. At family level, there might be issues of collective rape or actually forced marriages, especially to the girls that identify as lesbian. So all these are some of the challenges that criminal same-sex relationship puts on the lives of LGBTI people in Malawi. Now, getting to the second question on how this affects investigations, the first thing that you have to know is if somebody is not protected, that also affects their self-esteem. As such, even if when they've been victimized, you find out that they won't even go to the police to report the cases because they fear that if they're going to report, they're actually going to be re-victimized by getting arrested. So you find out that there's so many LGBTI people that are actually victims of violence based on SOGI, who do not even dare to go and report to the law enforcers for fear of being re-victimized. Apart from that, we've talked about examination of, forced annual examinations of people that are considered or that are caught, that are considered to be gay, more especially they that are considered to be gay. And then you find out that even in the when they have health problems to do with their sexual life, they may not even be able to go to the hospital to seek health services for fear of being reported to the police. Of course, now that has reduced because of the interventions that we are doing. But initially, or I would say formally, or in the places where we are not doing any work, or where any other LGBTI organization is not doing any work, some of LGBTI may not be able to access health services for fear of being ridiculed or asking questions that they're not going to respond to. So that's what I would say about the challenges that are to do with, that goes together with the investigations of cases that are to do with abuse of human rights based on SOGI. And
Rodney, that's fantastic, Rodney. Rodney, thank you so much. That's really helpful. I'm wondering, can I ask you a second question then? So as you know, local authorities and civil society organizations, including community-based organizations, play a particularly important role in preventing and monitoring violence against LGBTIQ plus individuals, especially in remote or marginalized areas. What do you think are the most constructive ways by which the state and civil society can collaborate in developing and implementing standards which can help to prevent that kind of violence or help to ensure accountability for it?
All right, I think the first thing, because all the problems are emanating from the sexual offenses within the penal code that criminalize especially same-sex relationships. So I think the first thing that has to be done is to review. I know that it has been reviewed for time that we cannot even count. Review the penal code sections that criminalize same-sex relationships. And if at all, they have to be scraped off from the penal code. The CSOs in Malawi can constructively work together with the government of Malawi to look into the laws that promote discrimination based on sexual orientation or gender identity. But apart from that, we have also to strengthen community structures. We've already got community victim support units within our country that also challenge discrimination of any sort, more especially gender-based violence. So if we can actually invest in strengthening community structures, the community victim support through awareness raising of LGBTI needs, that will also help. And another thing is, you'll find out that in Malawi, we don't have any other laws that protect people from being discriminated against or being stigmatized. So if we can come up with the laws that protect people against discrimination based on SOGI, that would be better. Because if I perpetrate on somebody's rights, or I abuse another person's right based on their SOGI, that person may not even go to report me anywhere because we don't have any other laws that protect the victims of such conditions. And also the other thing is, we know that knowledge is power, and knowledge starts from a time that a person is growing up. If we can actually make a deliberate effort to make our learning environment conducive enough for all people, including LGBTI learners, how can we do that? Most of our curriculum in Malawi, be it the education curriculum or health curriculum, or actually even the police training curriculums, they are devoid of issues that are to do with. So I think it's high time that we did that deliberately, making sure that learning starts from that tender age, that all people are equal and they are actually supposed to be accorded same rights without any discrimination. So those are the 4 ways that I propose that we can actually work together with the government of Malawi as CSOs to make sure that we provide a conducive environment for everyone.
Rodney, thank you so much. I think that's a really interesting mixture of a couple of different things that you've been able to present to us, both in terms of looking at some of the types of violence and difficulties and challenges that are faced by the community, many of them emanating from the state, from state actors, and then looking at the difficulties of actually being able to take an investigation because people just don't dare to report. And those things are all things which are very much part of the report that we're launching today. Those are reflected on in relation to different contexts and different jurisdictions in the report. But it's always good to set that against some of those positive things that civil society can do, and those really exciting ideas that you've, I know, been working on at SEDEC in terms of positive action that can be taken to try and challenge the laws or change them, to support the community by way of victim units and so forth, and to look at where the roots of some of these issues come from in terms of the education system. So Rodney, thank you so much indeed for now. We'll hopefully that will have stimulated some questions. Please put them in the Q&A function at the bottom, and we'll come back to Rodney in a little while to deal with some of those questions. So our second panelist joining us today is Imani Kimiri. Imani is a human rights lawyer who's dedicated to advancing the equality and inclusion of LGBTIQ+ individuals and communities in Kenya, as well as their meaningful engagement in society. Imani is the head of legal affairs at the National Gay and Lesbian Human Rights Commission in Kenya, UNEQUAL, where they use their experience and expertise in the advancement of human rights issues for LGBTIQ+ persons through legal aid, strategic litigation, public advocacy, and training and civil education on the rights and needs of sexual and gender minorities in Kenya. So Imani, welcome. Thank you for joining us. And my first question to you is, in response to violence against LGBTIQ+ persons in Kenya, UNEQUAL successfully litigated the issue of forced anal examinations before national courts, and this practice was ruled unconstitutional by the Mombasa Court of Appeal. And yet, in Kenya and in other African states, this remains a common practice to obtain evidence to support prosecutions of criminal offences related to same-sex activities. Could you tell us a little bit about UNEQUAL's experience litigating the case, and particularly the factors that you think contributed to a favourable decision? And in fact, has this judgment impacted the practice of that kind of violence against the community in Kenya?
Thank you so much, Chris. Sorry for that. Thank you, Chris. Good afternoon, good morning from wherever that you are joining us. And thank you so much for giving me this opportunity to be here for this webinar. In regard to the question that you've asked about, we at the National Gay and Lesbian Human Rights Commission have a legal aid center in which our sole purpose is to provide free legal aid for persons who are discriminated because of their real and perceived sexual orientation and gender identity. So in 2015, 2 people were arrested and were subjected to numerous testing, including forced anal examination, testing of hepatitis B, HIV, and all those. And what we did is we went to court, and after that, what my question particularly looks towards is what strategies did we put in place to ensure that we had a successful delivery of judgment, not only in the courts and also in the court of public opinion. So we, in the first instance, created a public, a public petition, where we were able to garner more than 777 signatures. The public petition was to seek the indulgence, or just to rally up the public so that they are able to realize and to petition the Office of the Director of Public Prosecution against, using such evidence that was taken or inquired, against our clients through torturous and inhumane treatment ways. We were also able to mobilize grassroots and mainstream organizations, queer and allied organizations, where we were able to come together in a brainstorm session just to think about what strategies we can put in place to ensure that these harmful practices continue being conducted in Kenya. And through that, we were able to have a human rights defender and a doctor who was a very good champion in our matter. And at that time, he was able to petition the Kenya Medical Association to set aside resolutions that are directing off the medical practitioners not to conduct medical examinations of any kind without the consent of, consent of the clients. And particularly these are, tests that were issued or judgments that had been delivered by the court, so that the doctors could conduct such tests. So we were able to also get that. We were also able to, conduct human rights and online and virtual campaigns in regard to stop forced examinations, stop testing, which went on for quite a long time. And through that, we were able to garner public support, as I have said earlier, in regard to just ensuring that doctors and duty bearers are able to just stop these forced medical examinations against people because of the sole purpose of getting, information or evidences that they could produce in court. However, even with the judgment that we have been given, there has been still practices, and some cases of forced anal examinations that are continually going on in instances where people have been arrested and are charged with sections 162 of the Penal Code, which talks about unnatural offenses. We've seen these cases happening, and what we currently are doing is we are increasing our advocacy efforts with the Office of the Director of Public Prosecution, so that they are just knowledgeable and are aware of the cases that are in court and the precedent that has been set apart, so that they can stop these harmful practices. Thank you.
Thanks so much, Imani. Let me also ask you then, the structural discrimination embedded in state institutions contributes to a general hesitation on the part of state authorities to do a proper investigation into violence against the LGBT+ community, or to prosecute, publish and punish perpetrators. I wonder if you can summarize some of the challenges related to the investigation of violence against LGBTIQ+ persons in Kenya. What do you think states could do to improve the effectiveness of their investigations into such violence?
Thank you, Chris, for the second question. I would echo the previous panelists who said the problem, and one of the biggest problems in countries such as ours is, the laws that directly criminalize consensual adult same-sex relationships and or even intimacy. And because of such laws, then we find it very difficult to have, police and also duty bearers be able to, investigate these matters without having biases, and also be when you're looking at their biases that are also coupled with discriminatory laws. That is also a very big problem. We also have challenges in situations where people who identify as intersex, gender non-conforming, and trans are held in prison facilities or detention facilities that do not conform with their gender. That is also a very big challenge. And this has, even with the Persons Deprived of Liberty Act that was enacted in 2014, even with this act in place, it still does not ensure that the persons who are deprived of liberty, who are intersex, transgender, homosexuals, are treated with the dignity that they deserve, they are deserving of. Another challenge would definitely be religion and religious aspects, cultural aspects, just general biases that different people, different duty bearers, have these lenses when they are interacting with cases that are involving of LGBTIQ people or LGBTIQ issues, and things are very difficult to change. But over time, NIGOLAC and other human rights defenders and queer allied organizations have been able to, advocate for, the inclusion of LGBTIQ people in laws, in policies, have been able to, just train or sensitize different service providers, stakeholders that are supposed to be the front line, the people who LGBTIQ people have access to when they are accessing justice or legal redress. So those are some of the ways that we are able to currently use, but it still has a long way to go, but then still we have come from a long way.
Fantastic, thank you so much. I thought that one of the really interesting things you were saying there, Imani, was about using the Kenyan Medical Association, and it seemed to me quite exciting to be kind of looking at ways of creating new alliances with perhaps organizations that we haven't previously thought of as necessarily being allies, but to try and create those kind of alliances. Was that a difficult process?
Not really, because during the period that we were trying to mobilize a brainstorming session, we were lucky to have the human rights doctor, his name is Dr. Bichanga, working for one of the partner organizations that we work with, that is the Independent Medical Legal Unit, IMLU in Kenya, who were also in attendance to that brainstorming session. So from that, then we were able to, have the strategies and the next steps, which involved him, being in a position in which he would be able to advocate for such issues, for LGBTIQ issues, to the Kenya Medical Association. So that was for us, I would say, luck. Is it luck? Mm-hmm. I would say that, but I wouldn't know the situation that would be with any other organizations or institutions that are seeking to, just to use other ways of advocacy, just using other efforts to ensure that their issues are actually being heard by the people who are intended to hear them. Yeah.
Thank you, Imani. That's really interesting. Thank you so much. Let's questions for Imani in the Q&A function at the bottom, but let's move on and talk to Ayo Sogunro, who's from the Sexual Orientation and Gender Identity and Expression and Sexual Characteristics Unit at the Center for Human Rights at the University of Pretoria in South Africa. Ayo is a Nigerian author, social entrepreneur and lawyer specializing in international human rights law, sexual minority law, sexual and reproductive law, policy research, and strategic litigation. He's the project manager of the SOGIESC unit at the Center for Human Rights at the University of Pretoria, where he consults for various international and local organizations on human rights policy, LGBTIQ rights, and human rights education. In 2017, he was listed as one of the 100 most influential Nigerians. He holds a Master of Laws degree in Human Rights and Democratization in Africa, and a Doctor of Laws degree in Sexual and Reproductive Rights from a critical legal studies perspective, both from the University of Pretoria. Ayo, I wonder if you can help us with this. In 2014, the African Commission adopted Resolution 275 on protection against violence and other human rights violations against persons on the basis of their real or imputed sexual orientation or gender identity. I wonder if you could explain for us some of the issues highlighted in that resolution and how it can be used for regional advocacy to address violence against LGBTIQ plus persons. And I wonder, in your experience, to what extent have states in the region taken concrete steps to implement the resolution? Thank you.
Thank you very much, Chris, and I am happy to be here today to participate in this discussion. The issue, of course, of violence against members of the LGBTIQ plus community in Africa, as well as people who are perceived to be sexual or gender minorities or even allies of sexual and gender minorities in Africa, is one that has weighed constantly in my work and in our work at the Center for Human Rights over the last decade. Resolution 275, at the time it was adopted, it was seen as a very significant victory for a lot of people working in the movement. It is the most significant document by the African Commission outlining the scope of the African Charter on the issue of violence and discrimination against persons in Africa on the basis of their real or imputed sexual orientation or gender identity. So the resolution itself urges states strongly, in very strong terms, to end all acts of violence and abuse, whether this violence or abuse is committed by state or by non-state actors. And of course, the key factors in order to do that is for states to enact and effectively apply appropriate laws that prohibit and punish all forms of violence targeting persons on the basis of their imputed or real sexual orientation or gender identities. And also for states to ensure proper investigation and diligent prosecution of all perpetrators. And even more importantly, to also establish judicial procedures that are responsive to the needs of victims. So we have this multi-layered basket of measures that states are expected to take. They are to end violence. They are to ensure that violence is punished by properly investigating and prosecuting perpetrators. And they are also to make sure that victims are not left behind in all of this process. Even though this resolution doesn't specifically talk about torture, it also covers the scope of what you understand as torture in international human rights law. Fine, the resolution is not a treaty document, so in that sense, the issue of whether it's binding or not may come into dispute, but we like to believe at the Center for Human Rights that it is binding because it has been adopted by the African Union Executive Council, and so AU member states have an obligation to implement its principles under the process of its adoption. But in terms of its implementation, that's now a different issue. Now, while we cannot say that we can directly trace this to the adoption of the resolution, we have certainly seen renewed decriminalization efforts in the time that the resolution has been adopted. We now have states like Gabon, Angola, Botswana, Seychelles, Mozambique, either judicially or legislatively, undertaking measures to push back against the legacy anti-gay laws or laws criminalizing same-sex conduct that they have on their books. That doesn't mean all is great, because on the other hand, we've now seen some other renewed efforts at recriminalization and persecuting members of the LGBTIQ plus community. So in that sense, the use of the resolution has still been quite limited. We know that part of the problem is around awareness. Most countries or most states and even activists working in this area do not still seem to be fully understanding of the scope of the resolution and all the opportunities embedded in it that can be used to ensure protection of the community. What we've been doing, though, is to look at some of the opportunities for accessing public institutions, for example, such as human rights institutions, and working. So, for instance, we've been working with the Network of African National Human Rights Institutions over the last 3 to 4 years to sensitize human rights institutions in Ghana, Nigeria, Kenya, Malawi, South Africa. And we have seen some progress in their own understanding of how they can use Resolution 275 to push back against state violence or violence by state actors within their jurisdictions. And we are trying now at the moment to put together some kind of documentation on the violations that has been going on in some of these states through the human rights institutions, and how these violations can be addressed in a more holistic way across the region. I think it's also important to mention that in South Africa here, the state has begun to take the initiative of encouraging other countries within the region to also implement Resolution 275. So yes, our Resolution 275 does offer a lot of opportunities, but sadly, the implementation is still very low. But the hope, of course, is that with this kind of conversations that we are having, and with the with more awareness being raised in the community and the movement, more and more people will begin to see opportunities for litigation, for changing public policy, and generally for holding states accountable under this resolution.
Ayo, that's really interesting. I didn't want to stop you. You've slightly run over the time that we allocated, but I didn't want to stop you because it was really important what you were saying. And you talked about some of the positive moves at the individual state level, but I wonder at the regional level, and in particular in relation to the African Commission, what do you think could or should be done to increase protection of the LGBTIQ plus community and increase accountability? Perhaps you can just keep this to a couple of minutes. That would be great.
I'll definitely do that. So yes, I mean, the African Commission, like I was saying earlier, has taken this step of adopting the resolution, and that has actually seen it face some existential threats from the political arm of the African Union, which has forced it into some kind of retreat, which in itself is a setback. But nevertheless, we still believe that the Commission still has to push on with this mandate to protect the rights of everyone. For one thing, the Commission needs to be able to take that symbolic step of granting observer status to LGBTIQ plus NGOs and create this, awareness that, look, human rights organizations that work on LGBT issues are also welcome at the Commission, despite what anybody else may say. This will help to create that awareness that is much needed to help boost the work of activists on ground. Then it would be nice, of course, if the Commission was able to actually do things like commission a study on the lived realities of the community to show how violence is still being deployed by state and non-state actors everywhere. And that awareness would help to bring more focus on the issue of torture, and even more critically, if the Commission can take some of these cases before the African Court to compel states to comply with their human rights obligations. I think I should just mention finally that beyond Resolution 275, there are some other guidelines by the Commission that can be used also as a starting point by activists to compel states to take action against torture. For instance, the 2015 guidelines on the conditions of arrest, police custody, and pretrial detention in Africa encourages states to take measures to protect the rights of sexual and gender minorities, as well as the guidelines for policing assemblies by law enforcement officials, which was adopted in 2017. And that guideline notes in particular that individuals and groups who are especially vulnerable to human rights violations in the context of policing assemblies should be specially taken care of. And states are even encouraged to include training regarding the safety and protection of sexual and gender minorities in the training of law enforcement officials. So there are some of these little things that, there is not quite holistic pattern yet, but they exist already within the documentation of the African Commission, which I believe that if we start all working together with, we can really effectively use to protect the rights of the community. Thank you.
Ayo, thank you so much. And I think it's always so important for us to try and put that resolution at center stage, really, of some of these discussions, because I do really think that the African Commission does have a real role to play in this, but perhaps hasn't fulfilled its potential just yet. So we may come back to that in the questions, but for now, Ayo, thank you so much. So I'm going to ask some questions that have come in from the participants to various of the panelists. So first of all, there's a question here for Imani. Thank you for your presentation and the great work GLERC is doing in Kenya. Given your previous experience in trying to garner government and public support to protect the rights of the LGBTQI plus community, would you say that there has been a notable positive change in attitude so far? That's the first part of the question. And the second part is this: with the upcoming presidential elections, do you have any forecasts or concerns regarding the state of LGBTQI plus rights under any new government? So 2 questions there for you, Imani.
Thank you so much for the questions. Of course, since the movement, I will begin with the first question. Of course, since the movement began in mid-90s to date, there has been considerable changes and shift in, perceptions of LGBTIQ people within the general society and the community. And this is owing to the fact that there has been a lot of work that has been undertaken by different institutions, different organizations in different parts of the country, as well as allied institutions and NHRIs, national human rights institutions, community-based organizations that have been doing different things and different things just to ensure that there's a foot in every situation, and there's basically, many ways in which people are able to, just advocate for such issues. So there has been an answer in that. There has been, of course, notably change, and this you can see even in how the media is even presenting or issues that are regarding to LGBTIQ. I know that it is a very worrying area, because the media sometimes can take certain steps towards correcting sensationalized issues, but then also take steps back, and that is also something that can be realized from what we do. But then if you're taking comparison in regard to how issues were being presented or even reported about, there has been significant changes in how these things have been reported, or LGBTIQ issues have been reported. There has also been significant changes in how medical practitioners deal with LGBTIQ people. However, this is something that is so minimal, because people still experience denial of services when they're accessing institutions, health institutions, and especially if it is in regard to matters that are affecting of them being LGBTIQ. So there has, of course, been a lot of strides, even within laws and policies that have been created. And in laws and policies, we can look towards judgments, and there has been very many positive judgments that have been set aside in court since 2007. When you look at the first case that was decided in court in regards to intersex persons and how they are deprived of liberty and how they should be handled in detention centers, that was one of the judgments that was delivered in 2007, and going all the way to matters of decisions of freedom of association for transgender people, freedom of association for lesbian, gay, and bisexual people, forced anal examination, and just forced medical examination that is conducted towards LGBTIQ people in instances where they need to extract evidence and use this to persecute LGBTIQ people. There also has been very good precedent in regard to change of names for the transgender community. So there has been a lot of milestones, as I would say, milestones that have been realized within Kenya, within the country, in regards to protection or just general observance of, and realization of LGBTIQ persons in Kenya. I want to move on to the second question, if that's okay.
If you could do it very, very briefly, Imani, because we're running short of time. But yes, something if you can forecast anything about how things might change under any new government.
So we are not blind to the fact that every time that there is elections in Kenya, LGBTIQ people have been used as scapegoats and political stepping stones for different people who are vying for political seats and political aspirants seats. So this has been the problem. And in the organization that I work for and work with, we have on so many years within the election periods received and recorded very large cases and large numbers of human rights violations that are occasioned towards LGBTIQ individuals. So I wouldn't be the best person to ask about what would happen in the event that there is a political shift and a different shift and a different person or different parties holding power once the elections come to pass. But I am not blind to the fact, as I have said, that during this time it's very tumultuous. It's a place in which it's very uncertain, and especially for LGBTIQ individuals. And the good thing is there has been different, human rights organizations, queer human rights organizations that have been looking towards strategies for protection of LGBTIQ people in the country to ensure that whenever this power changes or this power shifts, that there is minimal, violence, or even if the violence is occasioned towards LGBTIQ people, then there is ways in which we are able to, minimize the harm or be able to respond to such issues.
Thank you, Imani. That's great. Really, really interesting. Perhaps I can just move on to Rodney and ask a question that's come in. We're wondering, have you seen progress in Malawi regarding attitudes towards LGBTIQ plus issues, particularly in the police and other security forces over the time that you've been engaged in this work?
Can you please rephrase your question?
Of course. Have you seen progress in attitudes in Malawi on LGBTIQ plus issues, particularly in the police and other security forces?
Yes, we have seen some changes, but they are specific to individuals that we have interacted with. So I think what is most important is the entire system. If we talk about the Malawi police services, it is the entire system. And one thing that we all know is that the police people do not work at one station. Today they'll be here, and next year they'll be transferred to another station. So what happens is we have interacted quite a lot with the Malawi Police Service to the extent of working together jointly in one particular project that was meant to reduce the impact of stigma and discrimination experienced by LGBTI people. But the challenge is that that was a project, and we only managed to interact with just a few police people, police officers, and some of them might have left even the country or might have moved to another area where we don't do our work. So we would say that for the people or for they that we've interacted with, be it the police, be it the health service providers, be it the religious leaders, and even the parliamentarians, as well as the media fraternity, attitudes have changed, and they have actually helped in improving the attitude of people. But there is still more work to be done, because mostly if there hasn't been anything that has changed the system, then whatever projectized work that we are doing may not be as effective as we expected them to be. So yeah, I would say in a nutshell, there's some improvement, but there's some more work to be done.
Because on the one hand, Rodney, the constitution in Malawi provides good protection for everybody, respecting human rights, etc., etc. But on the other hand, the penal code prosecutes and denies full privilege of the enjoyment of human rights. So how do you see that kind of clash of those two ideas of protection on the one hand and of discrimination on the other?
Yeah, I think that's the biggest problem that we have, that our legal documents do not speak to one another, including the policies that we have in the country. They also don't speak to one another. So you find out that, as you've already put it, that our constitution is very enabling. It does not encourage discrimination based on any other condition. But the penal code happens to be taken as the major document by most people, not the legal practitioners, but we're looking at the public. They look at the penal code as something that they have to rely on, and they have to reference on any other time that we're talking against homophobia or transphobia or against any other discrimination based on SOGI. People will refer to the penal code. So just as I said at the beginning, I think there's a lot of work that has to be done in order for Malawi to repeal the penal code or to revisit the penal code and remove the sections that promote discrimination. So that's what I would say. But we have continued, or we continually are doing advocacy work together with state actors like Malawi Human Rights Commission, as I mentioned earlier on, that the law of Malawi needs to be used in order for them to be talking the same language. But unfortunately, of course, we know there was a time in Malawi when a law was actually brought into that promoted even more discrimination. That is to do with criminalization of same-sex sexual conduct between women. That law was not there before. But in the course of trying to make sure that the laws are speaking the same language, they brought a punitive law instead of scrapping another punitive law that we already had. So maybe there's so much work that we have to do in raising awareness, especially on the evils or the ills of perpetrating violence against one another. People are different in the way they love or in the way they manage their bodies.
Yes, Rodney, thank you so much. Now, an apology to everyone, really, that we're going to run a couple of minutes over time. I want to give Ayo a chance to answer one of the questions that's come in for him. And I'd encourage panelists, if you don't mind, to share perhaps your emails in the chat so that if people want to address their questions to you directly after the event today, that they might be able to do that. So I would anticipate we'll probably finish it by about 5 past the hour. So we're going to go over by about 5 minutes. So Ayo, I wonder, can you respond to this question that's come in from one of the participants? How can the international community, including sympathetic governments and parliamentarians, most effectively influence states to decriminalize same-sex conduct? What other steps could be taken by the African Commission to protect LGBTIQ people, and what can LGBTIQ plus groups do to enforce the implementation of resolutions? A lot of issues there. Perhaps you can touch on some of them at least, Ayo. Thank you.
Yes, indeed, that is a whole dissertation worth of questions. But I think I would summarize it by saying there are 2 key issues that both from my own research and from my work have become evident in the issue of decriminalization. One is the issue of the state and democracy and democratic systems in the state, because criminalization is not isolated. It is tied to the strength of democracy that exists within the country itself. In a country with strong democratic institutions, even if they are criminalizing laws, people will still have a space to discuss, to persuade, to advocate, and maybe convince, governments, or even take strategic litigation and get court orders that will be obeyed. And that is what we have seen, like, for example, in Botswana, which has a relatively stronger democratic institutions, where you can actually use the democratic structures to decriminalize the laws. And so what we try to do is to encourage more activists to be engaged with the constitutional and democratic systems by supporting the rule of law, the independence of the judiciary, the freedom of the press, and other systems which will then help to boost the movement for the LGBTIQ plus community. On the other hand, there is also the issue of focusing advocacy solely on the law without a corresponding advocacy with the people, because even if the laws change and the people are not carried along in the process, you might have a situation like what you have in South Africa, where only those who are privileged in certain ways will get the advantage or the benefit of the reformed laws, and it will not affect the poorest or the other most marginalized or vulnerable people in the society who do not have access or opportunities to take advantage of the law. So change should also focus on the hearts and minds of the wider society. And I know this can be a tough ask, because it almost sometimes feels like you have to be justifying yourself to people who don't even want to talk to you, who don't even want to, appreciate your existence at all. But it's necessary that in our advocacy, we are also sharing stories with society so that society can see the full scope of what it means to be a member of the LGBTIQ plus community. But like I said, this is going to be a longer, it's a very long distance, but certainly if advocates and the international community can focus on these two areas, and I think we can find somewhere to make progress from.
Thank you very much, Ayo, and thank you so much to all the speakers for their insightful contributions to this discussion, and to all of you for participating and bringing your questions. I'm so sorry we couldn't get to all of the questions. It's been a very rich and vibrant session, and I know there've been lots of interesting conversations starting in the chat as well. So thank you all so much for participating in that. We hope that you also now have a better understanding of what our new report covers. And so we're going to ask you a question, which you should see coming up on your screen, which is, how do you think you will make use of the report? And you can check more than one of those boxes. So if you think you're going to use it for many different things, you can tick more than one box. And if you can fill in that now, then that would be very helpful. So this webinar has highlighted the variety of factors that perpetuate violence and discrimination against the LGBTIQ plus community in certain parts of Africa, as well as those which prevent effective investigation into and prosecution of allegations of violence, and prosecuting this as torture where relevant. LGBTIQ plus persons continue to face increased vulnerability to various types of violence and torture. And at the same time, the continued perseverance of civil society organizations in the region, and even some positive developments in the judicial frameworks in some of the states studied, as we've heard this afternoon, give hope that these challenges may be overcome, in part by implementing some of the steps mentioned by our panelists today, as well as the recommendations put forward by our report. So we look forward to further engaging on this issue with our partners. We very much welcome comments, questions, and ideas in response to the report at any time. If you haven't already got your copy of the report, there will be a link to it in the chat in a minute, or otherwise you can find it on our website, redress.org. And we'd encourage you to share that report widely among your networks. And we would be really delighted to hear from you about the different ways that you've been able to use that report in your work. So before you disconnect, you'll see a final question on your screen. So please do let us know whether this webinar changed or contributed to your understanding of the challenges of legal protection and standards of accountability for torture against LGBTIQ plus persons in Africa. This one, I'm afraid you can only have one choice. So choose wisely and please fill in your answer. So finally, I'd like to say thank you very much again for joining us. And I very much hope that you've enjoyed this event today. Thank you.
Thank you very much.
So thank you so much, Rodney. Thank you, Imani. Thank you, Ayo, for joining us, and Lena for translating if she's still there. Many thanks indeed for contributing to this, and I hope that you've enjoyed the experience and made some connections, and that you enjoy reading the report as well.
Thank you so much, Chris.
Thank you, everyone. Lovely to see you.
Thanks a lot, Ayo. Nice to see you again.
Very much. Always happy to be part of your work.
Thank you very much. Likewise.
We didn't get a chance to say hello at the beginning.
Yeah.
Thank you, Ayo. Good to see you here again.
Indeed. So I think we can.
Thank you, Iman. We missed you.
I think Iman has dropped off.
I think she might have done. Anyway, thanks so much for your participation. Much appreciated, and we'll be in touch with you all soon.
Awesome.
Thank you.
Enjoy the rest of your and happy hideout beats to everyone out there.
Thanks very much.
Thank you.